I then give the floor to Mr. Tanzi to make his statement.
Mr. President, distinguished members of the Tribunal, good afternoon. It is a privilege to be appearing once again before you representing Italy, my country, in the last phase of the present proceedings. Opposing counsel yesterday affirmed that this case was a clear one. And if there is anything on which the parties agree, it is this, Mr. President. It is clear that this case is one about temporary probationary decree, that the decree has been adopted for the purpose of investigating alleged crimes, that the suspected crimes were allegedly committed in Italian territory, that the decree was lifted in August 1998. The decree was adopted in August 1998 at the time when the Norstar was in Spain's internal waters. That the Norstar did not leave those internal waters until the decree was executed by Spain in September 1998. That the decree was lifted, first conditionally in February 1999, and then finally in March 2003, and that the accused have never been imprisoned and that they have all been acquitted. Mr. President, distinguished members of the Tribunal, the case that Panama has advanced before you this week remains as misconceived as it was in Panama's written pleadings. Italy has already provided comprehensive responses to Panama's confused submissions, both in its written pleadings and this week. I will therefore confine my rebuttal speech by highlighting just the most fundamental failures in Panama's case. Mr. President, my speech is organized in four main parts. In the first part, I will address 5 main flaws which characterize Panama's case. They are the following. A. Panama continues to enlarge the scope of the dispute as defined by this tribunal in its judgment of 4 November 2016. B. Panama characterizes Article 87 as a provision without geographical limits. C. Panama attempts to plead a breach of Article 87 without demonstrating any interference which could impinge on the freedom of navigation. D. Panama misunderstands the relevance of the acquittals of the accused. E. Panama baselessly accuses the Italian public prosecutor of arbitrariness. The second part deals with Panama's improper approach to the present proceedings. To that end, I will consider A. Panama's false allegations of imprisonment, B. the boldness of Panama's claim, C. Panama's delays in commencing this case, D. Panama's gross and repeated inflation of its damages claim. The third part of my speech will rebut Panama's allegations concerning the prosecutor's conduct. In particular, I will address A. the reasonableness of the prosecutor's actions, B. the limitations of the prosecutor's responsibility for the execution of the decree of seizure. In the fourth part, Mr. President, I will consider briefly the valuation of the Norstar, and I will then end with the conclusions that Italy draws from Panama's approach to the case and its conduct as applicant throughout the proceedings. Mr. President, distinguished members of the Tribunal, you have already had counsel for Italy, including myself, criticize Panama's attempts to exceed the boundaries of the current dispute on a number of occasions this week. I will therefore be brief on this, but I must emphasize this point here again because it is foundational to the scope of the judgment you will deliver on the merits, and because Panama continues to ignore those boundaries. Panama had launched this case on the basis that the subject of the dispute, as Panama described in its application, quote, concerns a claim for damages against the Republic of Italy caused by an illegal arrest of the MV Norstar, unquote. That claim is no longer before the Tribunal, Mr. President, as you made clear in your November 2016 judgment in paragraphs 122 and 132, as I already recalled earlier this week, the Tribunal's jurisdiction is limited to determining the legality of Italy's decree of seizure and request for its execution under Articles 87 and 300 of the Convention in relation to Article 87. What that means in short, Mr. President, and recalling further detail in my speech on Wednesday, is the following. A. Panama's continued attempts to make this case about the arrest of the Norstar must fail. It is the decree of seizure, together with the request for its execution, which are relevant acts to the present dispute. Meanwhile, the execution was carried out far from the high seas in Spain's internal waters, and such acts cannot be attributed to Italy. In other words, Mr. President, the key event upon which Panama brought this claim in the first place is no longer relevant to this dispute. B. Panama's continued attempts to plead breaches of Articles 92 and 97 of the Convention must also fail, Mr. President. These articles lie beyond the scope of the Tribunal's jurisdiction as defined in its November judgment. Panama has failed to prove the contrary. C. Panama's attempts to plead breaches of various human rights obligations which it maintained in its written pleadings and somehow in its oral pleadings must again fail. The Tribunal has no jurisdiction to determine breaches of such obligations, which are contained in separate treaties that have their own enforcement regimes. However, Italy is pleased to have had the opportunity and the privilege to illustrate before this Tribunal the full conformity with the basic principles of fair trial and due process of law by its judiciary. Mr. President, members of the Tribunal, I will now address how Panama characterizes Article 87 as an obligation with no geographical limits. In so doing, Mr. President, Panama carries out its attempt to enlarge the obligation under this article to an extent which is not tenable. On Monday, Mr. Morsch vaguely asserted, without any substantiation, that the Norstar had made a voyage to Algeria in July 1998. But neither Mr. Morsch nor anyone else on the Panama side has substantiated that the Norstar was anywhere but in Palma de Mallorca from the time of the decree of seizure, namely 11 August 1998, to the time of the Norstar's arrest, the 25th of September 1998. That is the only time period that can be relevant in light of the jurisdictional boundaries of this dispute. And yet, Mr. President, Panama's case revolves around the claim that Italy's decree of seizure and request for its execution somehow breached Panama's right to freedom of navigation on the high seas. My colleague, Professor Caracciolo, has extensively demonstrated on Wednesday why Panama has failed to establish a breach of Article 87. Therefore, it suffices to recall, as a general matter, that Panama's attempts to ignore the actual location of the Norstar at the time of the conduct that it challenges is gravely misconceived. Mr. President, this amounts to a fully fledged attempt at rewriting Article 87 of the Convention, as if it applied anywhere and everywhere that a ship may be, even in internal waters, so long as the ship sometimes traverses the high seas. That is clearly wrong. And in any way, Panama has failed to set down any way in which this extraordinary enlargement of Article 87 may be reasonably confined. Nor has Panama paid any attention to the dramatic consequences its new interpretation of the law would have for state sovereignty, including its enforcement powers to investigate and adjudicate crime in its internal or territorial waters. Panama's failure to recognize the geographic limits of Article 87 is fatal to its claim. As it is well known, the law of the sea is characterized by a fragile balance between the powers of the coastal state and jurisdiction of the flag state, a product of centuries of state practice and difficult negotiations. This is why the Convention and freedom of navigation should be handled with care. Commentators on ITLOS in the literature agree that the Convention strikes a carefully considered balance, and I quote, "One of the enduring characteristics of the law of the sea convention is the manner in which skillfully balances rights and duties in an equitable manner and advances global interests for the benefit of the common good. This balance is very much evident in the key provisions of the Convention, including many ambulatory references to the freedom of navigation in the exclusive economic zone and on the high seas that permeate the entire text of the Convention," unquote. Mr. President, members of the Tribunal, I should further add that Panama claims that Article 87 should be intended as entitling a ship to gain access to the high seas even when the ship is legally detained in port. Panama attempts to distinguish the Norstar case from the Louisa case, in which the Tribunal has already rejected the claim that Panama is now attempting. According to Panama, the difference lies in the fact that in the Louisa case, the relevant conduct occurred in territorial waters, whereas in this case, the conduct occurred on the high seas. Let me answer this argument, Mr. President, by quoting the opinion of a distinguished member of this tribunal, and I quote, "Article 87 covers freedom of the high seas and in particular freedom of navigation. But the existence of a basic freedom does not prohibit the coastal state from exercising powers of its police and judiciary in its own territory. The parties argued about the location of the alleged criminal activities, internal waters, territorial sea, exclusive economic zone. The applicant maintained that its scientific research activities had been conducted within the area covered by the Spanish permit, that is, the internal waters and territorial sea. The respondent does not dispute this, but is the issue truly relevant? Question mark. End of quotation. No less remarkable, Mr. President, is Panama's further attempt to enlarge Article 87 by bringing a claim on no actual interference with the freedom of navigation. The simple reality of Panama's claim is that the only relevant conduct of Italy before this tribunal, the decree of seizure and the request for execution, had no effect whatsoever on the Norstar's navigation on the high seas. Panama is so well aware that no interference had at all occurred that it tried yesterday to propose a concept of indirect interference which de facto reasserts Panama's claim that to investigate conduct on the high seas or extend to the high seas the legislation of a coastal state amounts per se to an interference with the freedom of navigation. Mr. President, this is plainly wrong. In order to make up for its inability to prove any interference, the Panamanian narrative went on so far as to submit, for the first time in this proceeding, and after having seen how Italy pleaded this point in its written pleadings, that the Norstar was harassed. On this point, the witness statement of Mr. Husefest is vague and unreliable about time and circumstances. For the record, the question is not whether the Norstar experienced any interference on the high seas at any point of its life, but whether the decree of seizure and the request for its execution determined any interference. An interference did not occur even in the tenuous form of a chilling effect. I recall that President Esposito confirmed on Thursday that a probationary seizure of an object such as a ship is secret until it is carried out. This necessarily means that no one involved with the Norstar knew or could have known of the decree before it was actually enforced in port. No way that the decree could display any chilling effect. A further point concerning extraterritoriality. The tribunal asked whether the decree of seizure and its request for execution with regard to activities carried out by the Norstar on the high seas amount to breach of Article 87. Italy wishes to stress once more that extraterritorial exercise of jurisdiction, which Italy has not exercised in this case, does not in any event amount to automatic interference with freedom of navigation. While there may be conduct by a state that breaches at the same time Article 87 and those distinct provision of the ITLOS prohibiting extraterritoriality, such as Articles 89 or 92 and others, no breach of Article 87 can occur unless there is some sort of interference with navigation. Thinking otherwise, Mr. President, is contrary to ordinary principles of interpretation of the ITLOS, such as effet utile and interpretation in good faith, inasmuch as it deprives Article 87 of its characterizing purpose. Mr. President, members of the Tribunal, I will now address Panama's misunderstanding of the relevance of the acquittals by the Savona and Genoa courts in 2003 and 2005 respectively. Agent and counsel for Panama have repeatedly invoked the acquittals of those involved with the Norstar by the Tribunal of Savona as somehow proving Panama's case, but have already illustrated on Wednesday and repeated on Thursday that this is wrong for at least two reasons. First, it is the Tribunal of Savona's decision to acquit the accused that is relevant for our purposes, because it was on the same judicial occasion that the decree of seizure was definitely lifted. And that decision was entirely separate from any assessment of lawfulness or otherwise of the decree of seizure in question. Indeed, the Tribunal of Savona did not say anything about the lawfulness of the decree of seizure, and that is unsurprising. It is ordinary, Mr. President. It is the law. That is the due process of law. The fact that an accused is ultimately acquitted does not mean that the investigation of that individual that led to its acquittal was unlawful. Let me repeat, Mr. President, once again on Panama's view of the law. Investigatory measures such as probationary seizure of property retrospectively becomes unlawful every time the accused is acquitted. That would be producing disastrous effects on investigation of suspected crime and must be wrong. Logically and legally wrong. Second, even if the acquittals of those involved with the Norstar did somehow, only arguendo, mean that the probationary seizure was unlawful under Italian law, that would not obviously mean that Italy had breached international law. It would serve to demonstrate the very non-arbitrariness of Italy's conduct under international law. As the International Court of Justice put it in the ITLOS case, and I quote, "It would be absurd if measures later quashed by higher authority or a superior court could for that reason be said to have been arbitrary in the sense of international law," unquote. Mr. President, that point ties in with one of the recurring themes of Panama submissions, both in its written submissions and this week, which has been Panama's accusation that the conduct of the Italian public prosecutor was arbitrary. Thus, Mr. Carrillo accused Italy, through that public prosecutor, of arbitrarily preventing the Norstar's access to the high seas. Panama even accused the prosecutor of pursuing an investigation, knowing that there was no lawful basis for it. Mr. President, distinguished members of the tribunal, these are serious allegations. These are serious allegations that Panama has fallen well short of establishing. To take just one of Panama's gross failures to discharge its burden of proof, the tribunal may recall Mr. Carrillo's attempts to cross-examine Italy's Italian law expert, President Esposito. He examined President Esposito about whether the public prosecutor in this case gathered any evidence from the Norstar during its probationary seizure. That was a strange line of questioning in the first place, given that President Esposito served as an expert witness and not as a fact witness in this case. It was therefore unsurprising that President Esposito could not comment on that matter. But what is important that Mr. Carrillo's line of questioning underscored in crystal clear terms is the remarkable difficulty of Panama's efforts to find evidence to sustain its bold assertions of prosecutorial arbitrariness in this case. In other words, Mr. President, having advanced no evidence of its own, Panama tried to fish for such evidence from an expert witness. The baselessness of Panama's attempts to criticize the conduct of the public prosecutor should not go unnoticed by the tribunal. On the contrary, as it will be discussed in further detail shortly, the conduct of the Italian authorities, including the public prosecutor, was not only in good faith, it was at all time reasonable and proportionate, and was carried out in conformity with Italian law and the European and international due process of law and fair trial obligations and standards. As I illustrated on Thursday, Mr. President, I must make one important clarification here. The agent for Panama has asserted that Italy is impermissibly seeking to set up its own domestic law as a justification for its conduct under international law. But that is not what Italy is doing. Italy is simply relying on its domestic laws as providing critical facts for this tribunal when assessing its conduct in light of international law. Mr. President, allow me to turn again to the ITLOS case, which I hold particularly dear, and in particular to its definition of arbitrariness under international law as, quote, a willful disregard of due process of law, an act which shocks or at least surprises a sense of judicial propriety, unquote. That definition underscores the importance of looking at the seriousness with which a state's authority take legal processes. Panama, as will be discussed shortly, has no basis for alleging that the Italian public prosecutor or any other public authority willfully disregarded the relevant legal processes. Mr. President, members of the Tribunal, having outlined those fundamental misconceptions with Panama's claim in this case, I now wish to make some remarks about Panama's improper approach to the procedure of this case. It is important that I underscore these aspects because if the 5 fundamental misconceptions in Panama's claim were not enough, Panama's improper approach to the procedure of this case reinforces the lack of seriousness of Panama's claims. Mr. President, Panama launched this case with the allegation under the rubric legal grounds in its application that, quote, after imprisoning members of the crew of the MV Norstar, the Italian Republic has up until this date evaded to account for this event, unquote. As I have already told the tribunal, Panama has now conceded that no one involved with the Norstar was ever imprisoned in connection with the Norstar, with the Norstar's arrest, or after. Panama must have known this, or should have known this, at the time it made its application. I know, Mr. President, I have already addressed this point, but allow me to underline that whether someone has been imprisoned or not is not a point on which there can be any ambiguity. Yet, Panama knowingly made that false allegation and thereby attempted to aggravate the dispute before this tribunal. And it is also to be emphasized that these false allegations were reiterated by Panama in the memorial. And it was only after Italy noticed the falseness of these contentions that in its reply, Panama withdrew such allegations. That, Mr. President, tells a lot about Panama's fast and loose approach to the matter of evidence in this dispute, and about the recognition that by Panama of the weakness of its case without such an allegation, as well as Panama's fast and loose approach to matters of evidence in this dispute at large. Panama, as well as launching this case on the back of false assertions, also more broadly launched this case without any evidential foundation. Panama's continued attempts to blame Italy for Panama's inability to furnish adequate evidence in this case, including this week, reveals that this case has been only built riskfully and without foundation. You may recall that Panama's overbroad document requested attempts were expressively premised on this lack of evidence. As Panama explained in the request for evidence that it filed with its memorial, I quote, taking into account the lapse from the date of the initiation of damages, nearly 20 years, and due to other different factors, time, distance, language, and economy, it has proved difficult to examine and provide the tribunal with documents concerning this case, unquote. I know about the difficulties that Italy had to find its documentation about a very old case. But it was not our case, Mr. President. It was Panama's case. Italy has made significant efforts to cooperate with Panama and respond reasonably to Panama's document requests, including those made in Panama's memorial, notwithstanding the lack of specificity. Italy even offered to provide a list of documents it held so that Panama could provide proper, specific document requests. Panama refused to take up that undue, and I repeat, undue cooperative proposal. Panama must now bear the consequences of that refusal. It is not for Italy to provide Panama with all the evidence it needs to build its case. Numerous authorities confirm the basic principle of litigation, including Professor Robert Kolb in his chapter on General Principles of Procedural Law, and I quote, "The principle of cooperation is limited by its aim, which is to allow the fulfillment of the object and purpose of the proceedings, that is, a proper administration of justice. It obviously does not extend as far as to ask the parties to share information or to compromise their egoistic interests as opposing parties. For this would again be incompatible with the object and purpose of the proceedings, which is litigation from the standpoint of contrary interest. Adversarial proceedings," unquote. And the adversarial nature of this proceeding didn't seem to have escaped opposite counsel, nonetheless. The tribunal recognized this principle by rightly rejecting Panama's overbroad documents requests. Panama still refuses to accept that decision, as shown by the vague questions put this week by its counsel to President Esposito about the circumstances in which a criminal file could be requested in Italy. But it remains the case that Panama cannot shift the blame to Italy for its own failure to provide adequate evidence in this case. It is worth mentioning that Mr. Morsch could have asked the tribunal to have access to all the files and documents pertaining to criminal proceedings, as the Italian Code of Criminal Procedure prescribes in Article 111. Him and his lawyers, his attorney, for which we have evidence that there was retention and fee, has not taken action to that effect, but is asking Italy to make up for that. If there was anything to make up for, Mr. President. Nor can Panama make up indeed for its evidential failures through the oral testimony of self-interested witnesses. Mr. President, members of the tribunal, we have heard opposing counsel insist yesterday that Panama had met its burden of proof because, and I quote, "the testimonies of the witnesses called by Panama in this case, Mr. Morsch, Mr. Rossi, Mr. Husefest, were a particularly strong evidence because the witnesses were directly involved in the events surrounding the Norstar and had extensive knowledge of the facts concerning the vessel and its activities, unquote. We reject, Mr. President, that evidence of these witnesses provided was at all compelling in respect of the key facts in dispute in this litigation, and we will discuss at various points today why that is so. But I also want to challenge the strength of that oral evidence as a general matter based on well-accepted principles in international dispute settlement, affirming that the evidence of individuals that have an interest in the case, and especially a financial interest, has less value than the evidence of those who do not have such an interest. I recall here the statement of the International Court of Justice in the Nicaragua case as follows, I quote, "In the general practice of courts, two forms of testimony, which are regarded as prima facie of superior credibility, are first, the evidence of disinterested witnesses, one who is not a party to the proceedings and stands to gain or lose nothing from its outcome. And secondly, so much of the evidence of a party as is against its own interest." End of quotation. I should add, Mr. President, that this case involves a state exclusively, if not preponderantly, bringing a claim not for itself, but for the financial benefit of Mr. Morsch, a Norwegian national, and his associates, including Mr. Rossi, an Italian national. And those witnesses have given evidence not to vindicate the legal rights of their home state, or perhaps not really even of the flag state, but in order to obtain financial compensation for themselves. We ask the tribunal to have close regard to this feature of the case when assessing the credibility or lack thereof of these witnesses. Nor can Panama, Mr. President, blame the lapse of time for its evidential difficulties, given these have followed from its own tardiness in commencing this case. And this was despite Mr. Carrillo having powers of attorney since the year 2000 and threatening almost immediately to file a prompt release claim or otherwise against Italy before international adjudication, while the case was pending before Italian courts. We also know from Panama's damages claim that Mr. Morsch had retained, as I already alluded, other legal counsel following the arrest of the Norstar. In particular, it has become apparent in the course of the oral proceedings that Panama's case fails to meet the required standard of proof on certain critical aspects, including, for instance, that the ship was actually on the high seas at the time of the decree of seizure and the request for execution. It was in this connection that during the redirect examination, agent for Panama asked Mr. Morsch whether the whereabouts of the Norstar would be known for certain had the logbook been available. Mr. Carrillo's suggestion is perhaps that it is due to Italy's fault that some crucial documents, such as the ship logbook, are no longer available. It is important to stress, Mr. President, that this is not the case. In his redirect examination of Mr. Morsch, Mr. Carrillo asked, quote, "Do you know what happened to the books?" Unquote. Mr. Morsch's answer was, quote, "The logbooks were still on board in 2015 under Italian detention," unquote. one part of Mr. Morsh's witness is certainly wrong. The ship in 2015 was not under Italian detention. In 2003, Italy lifted the seizure of the vessel unconditionally. However, Mr. President, let me focus on the other part of Mr. Morsh's testimony. Quote, "The logbooks were still on board in 2015, unquote. If Mr. Morsh, acting with Panama, intended to bring a case against Italy concerning the arrest and detention of the Norstar, why did he not recover these documents, which he testified were on the bridge in 2017, when the application introducing this case was filed? More generally, it was not for Italy, especially after 2003, to take care of the conservation of evidence concerning the MV Norstar, which from the Italian perspective was concluded in 2003, 15 years before. Further still, why did Panama wait until November 2015 to bring a case against Italy? Namely, 3 months after the Norstar was destroyed and all related evidence dispersed. Panama had 18 years to bring this case against Italy. During all this time, the documents of the ship would have been available. The ship itself would have been available. Certainly, any lack of evidence in this case is not of Italy's making, and it should not be imputed to Italy. I should add here that in its November 2016 judgment, the tribunal recognized that principles like extinctive prescription and acquiescence are general principles of international law, and that the tribunal is to take them into account in light of Article 293 of the Convention. While the tribunal found that Panama's claim was not time-barred due to the lack of a specific time limit for the operation of extinctive prescription in international law, this does not mean that the tribunal should not take into account for other purposes the fact that a long time has elapsed since the facts that are at the basis of the Norstar case in this merit stage. This, Mr. President, is especially the case in circumstances in which the unreasonable delay in commencing this case is imputable to Panama and not to Italy. Again, Professor Robert Kolb, in describing the rationale of extinctive prescription of a claimant's claim, observed that, and I quote, "There are many legal reasons for some limitation in the legal order, including equitable considerations, since it may become difficult to defend a case. After a long time, the relevant pieces of evidence and proof not being available anymore," unquote. And we know that for experience, Mr. President. Those considerations apply equally when assessing the state of the evidential record following a long lapse of time. As the tribunal in the Gentini case recalled, and I quote, "Great lapse of time is known to produce certain inevitable results, among which are the destruction or the obscuration of the evidence," unquote. Mr. President, members of the tribunal, one of the most abusive features of this case, which you have no doubt already noted, is the dramatic way in which Panama has grossly, repeatedly inflated its damages claim. In its application, Panama quantified its damages at above $6 million plus interest. That became $13,721,000 and the number of dollars and cents in Panama's memorial. By the time of Panama's further submission that inappropriately filed outside the procedural schedule and on the same day as Italy filed its rejoinder on 13 June 2018, and in sums that it outlined yesterday, Panama's claim had risen to 27 million and something US dollars, plus almost $25 million in interest, plus 170,000 euros in legal fees, plus 26,000 euros in further interest. Mr. President, that is over 50 million US dollars in total. In other words, Panama's damages claim has increased over 800% during the course of this dispute. Mr. President, there is little that could undermine a claim more than the fact that the party making that claim has no idea what it has lost. That Panama's damages claim has just happened to have continuously skyrocketed upwards betrays Panama's claim as nothing short of opportunism and contradicts any suggestion that Panama has ever been interested in the legitimate settlement of this dispute. Mr. President, members of the Tribunal, I will now address Panama's contentions regarding the public prosecutor. I will first deal with allegations regarding the lack of reasonableness of the prosecutor's action. I will then address the issue of the limitation of responsibility of the prosecutor that was not responsible for the execution of the decree and the custody of the Norstar. Counsel for Panama continue to make numerous assertions regarding the conduct of the public prosecutor that are devoid of any evidential foundation, which are contradicted by basic principles of criminal justice. In particular, yesterday, Panama elaborated at length on the decree of seizure adopted by the public prosecutor of Savona. What Panama did was to provide a misleading portrayal of selected fragments of the decree. The result was a narrative that does not correspond to the actual factual and legal circumstances grounding the decree. Excerpts of the decree are shown on the screen, but it is unreadable to me, and I suppose by the judges as well. And I regret that, but I'm sure that this being the heart of the disputed facts, distinguished members of the Tribunal and the President will have no difficulty in retrieving this text. And as far as the marked parts of this text, if allowed, we will be pleased to submit a version with marking. Around this text, Mr. President, Italy intends to respond point by point to Panama's misinterpretation. First, Panama reiterated its assertion that Italy aimed the decree at targeting bunkering activities on the high seas carried out by the Norstar. Italy once again is obliged to recall that bunkering is lawful under Italian law and that none of the crimes mentioned in the decree consist in refueling gas oil offshore. As Italy has maintained since the beginning of the merits phase of this proceeding, the Italian fiscal police were instead investigating several suspected legal offenses, fiscal offenses, under Italian law, on Italian territory. In addition to Italy's pleadings earlier this week, I may refer you specifically to Annex A to Italy's counter memorial, which you may also find on the screen, perhaps in more readable conditions. You have there the Fiscal Police Investigation Report of 24/1998. In jargon, it is called, under Italian law, Notizia Criminis. This document reports the outcome of the investigations as of 24 September 1998, and it clearly demonstrates that bunkering was not the activity under investigation. On the contrary, that report shows that the Italian fiscal police had reasonable grounds to suspect and to further investigate alleged fiscal offenses which were part of a unitary composed criminal plan put together by an Italian national, Mr. Silvio Rossi, and involving the participation of the management of foreign companies, including Intermarine, as well as the master of the MV Norstar. In summary, Mr. President, that suspected criminal plan included several phases. First, the loading of the Norstar with fuel in Livorno, Italy, in exception of excise duties and VAT, as ship store. 2, the reintroduction of the fuel into Italian territorial waters and or internal waters. And 3, the sale and purchase of fuel in Italy, avoiding the payment of the fiscal duties due under the Italian law. None of that conduct, Mr. President, has anything to do with bunkering on the high seas. Let me be clear, Mr. President, if you search for the word bunkering in Annex A, the report of the investigations, you will find it. However, the investigation of bunkering per se was not the rationale of the investigation, as we heard yesterday. Rather, the fiscal offenses that occurred in the Italian customs territory, including internal waters and or territorial sea, those were clearly the rationale of the investigations, Mr. President. It is on the basis of these investigations that the public prosecutor adopted the decree, which is at the center of your attention. Yes, the decree was adopted shortly before, but as myself before, Mr. Esposito confirmed, there was close contact between the public prosecutor and the investigating authorities who have been working back to back for almost a year. And that is the rationale of the pertinent criminal procedural rules on the issue. Second, Mr. President, Panama underlines that the decree of seizure refers explicitly to the constructive present doctrine and hot pursuit. No denying, Mr. President. According to Panama, constructive presence and hot pursuit constitute the rationale behind the decree of seizure, unquote. Panama also asserted that the reference to this doctrine shows, quote, that the use of this doctrine in the decree of seizure in itself proves that the Norstar was not seized for activities in the territorial waters of Italy, end quote. But Panama's assertion is wrong, even if the public prosecutor referred to constructive presence and hot pursuit. These did not form the operative part of the decree. Such references did not form the operative part of the decree, which was instead based on the prosecution of the alleged offences plainly committed in Italian territory. And most importantly, Mr. President, as we have repeated time and again, the fact of the matter is that the Norstar was never arrested on the high seas. In particular, as far as hot pursuit is concerned, which was never carried out, by the way, this nonetheless indicates that any intention to arrest the Norstar on the high seas involved doing so in compliance with the right to hot pursuit under Article 111 of ITLOS. If there were to be any arrest on the high seas under this decree, it would have been carried out only under the requirements of Article 111 of pursuit. Third, Mr. President, members of the Tribunal, Panama recalled Annex 7 of the memorial, containing a letter from Telespresso, dated 4 September 1998, issued by the Service of Diplomatic Litigation, or Legal Directorate of the Ministry for Foreign Affairs of Italy, to the prosecutor who signed the decree of seizure. As the Council to Panama notes, the decree of seizure in question refers to the Spiro F, flying the flag of Malta. It is not the first time that Panama attempts to introduce the Spiro F case into the present case with the aim of blurring and confusing the facts and the legal context. Panama suggests that Italy has somehow been evading the Spiro F case. But what Italy and its agent has objected to was that the Spiro F case is a fundamentally different case. And I am pleased to have the opportunity, Mr. President, to underline that difference in light of Panama's insistence on the Spiro F. This difference, Mr. President, is simply that while the Spiro F was arrested on the high seas, this did not occur in the Norstar case. This again underscores one of the core failures of Panama's claim for a breach of Article 87 in this case. Mr. President, moving beyond the decree itself, Panama also continues to badly understand how probationary seizure works. Counsel for Panama thus complained yesterday, and allow me to quote, "The Italian legal expert yesterday said that since it was a probatory seizure, for a prosecutor to arrest a foreign ship, the existence of a crime did not have to be proven. So, our first question to Italy will be, in Italy, for a foreign vessel to be arrested, even for probatory purposes, is it not necessary to have proven the existence of a criminal offense?" End of quotation. Mr. President, members of the Tribunal, of course it is not necessary to have proven the existence of a criminal offense before a probationary seizure is to investigate the seized property precisely in order to determine whether there is evidence of the existence of a criminal offense. as counsel to Panama accepts, President Esposito confirmed this in his testimony, and Panama did not challenge this in cross-examination. Thus, when Mr. Carrillo asked President Esposito, quote, "Is the guilt of the accused person necessary for the adoption of a probative seizure?" End of quotation. President Esposito answered, "No, absolutely not." Panama's continued attempts to challenge this clear law is not only nonsensical, it also flies in the face of the evidence. Panama also contests the reasonableness of the public prosecutor's decree on the basis that it was not justified by necessity. Panama refers to the passage of the decree stating that, and I quote, "Having noted that the seizure of the mentioned goods must be performed, as it has an intrinsic probationary nature with no need to assess whether the order is necessary." End of quotation. As explained by the expert in Italian law, President Esposito, on Thursday, probative seizure is different from precautionary seizure. And so are their respective requirements for legitimacy and lawfulness. While the precautionary seizure requires, I quote, urgency, the former only requires a reasonable suspicion that a crime has been committed. That is the fumus boni iuris, on the ground of which you engage into investigation, or you continue investigations in order to attain, to search the truth, which would lead to condemnation or to acquittal. Therefore, fumus boni iuris is to ground the investigative necessity to gather information to collect evidence. And it is in this sense that it is urgent and necessary inherently, per se, as such. Mr. Busco, referring to the Italian Court of Cassation, has covered this point on Wednesday, and I may refer you to his very clear speech. I may only add here that in any criminal justice system, decisions on whether to move forward with investigations and probationary seizures that are part of those investigations are not based on considerations of urgency, as may be the case, for example, with preventive seizure taken to prevent the destruction of property. Let me address, Mr. President, one point raised by Panama yesterday concerning the fact that the probative seizure would be a measure exclusively peculiar to the Italian legal order. This is patently wrong. The probative seizure is an act well known in the legislation of other states. I may refer inter alia to the British, German, Spanish, US legal system. This may come as a surprise to Panama that Article 252 of its Code of Criminal Procedure contains a similar measure. Article 552 is akin to Article 253 of the Italian Code of Criminal Procedure in providing a measure aimed at gathering of all evidence needed to substantiate the allegation. And I suppose that counsel for Panama are also familiar with the difference between Article 252 of the Code of Criminal Procedure and Article 259 of the Code of Criminal Procedure of Panama. Mr. President, members of the Tribunal, the Norstar was put under probative seizure on 25 September 1998 on the basis of the decree of seizure of 11 August 1998. Thus, urgency was not a requirement. whereas necessity followed inherently from the finding of the fumus without having to be separately established. As to the fumus, Panama asked yesterday, quote, has Italy provided evidence about how many of all those mega yachts supplied with bunkers on the high seas went back to Italy in order to affirm that there was a suspicion of a crime of smuggling and tax evasion having been committed? Mr. President, members of the tribunal, one would suppose that one of the main reasons for conducting investigations complained of would be precisely that of trying to assess, ascertain, find out these kinds of facts. But if we leave suppositions aside, Mr. President, it turns out from the investigation report, which I referred to a while ago, and that you find in Annex A of Italy's Counter Memorial, that the investigations led to the assessment within a time span of 10 days, namely between 3 August 1997 and 13 August 1997, that 8 yachts had been refueled by Norstar and entered the territorial waters of Italy. And what is also of peculiar interest for us to know from that document, which you find again in the same Annex A, is that you find out that the fuel sold to those Italian buyers was invoiced to foreign fake buyers, including Nor Maritime Bunker, for purposes of avoiding the payment of VAT and income taxes. Panama also continues to make irresponsible assertions about the alleged motives underlying the public prosecutor's actions, including referring to Mr. Rossi's accusation that this was done in bad faith for the purpose of carrying out a prosecutorial zeal. But this is not acceptable for Panama to rely on such accusations without any supporting evidence. And of course, the tribunal well knows that bad faith cannot be presumed. The public prosecutor set out the reason for his decree in that decree, and the results of the complex investigations are described therein that go in the same direction. I should also add briefly that Counsel for Panama criticized yesterday President Esposito for not knowing the motivations of the public prosecutor. But such criticisms are misguided. President Esposito, as you well know, is an expert witness here to give testimony on the principles of Italian law. He is not a fact witness who could possibly comment on the public prosecutor's motivations. I can add, though, Mr. President, that the rigorousness of the public prosecutor's conduct is underscored by the speed with which he progressed his investigations of the seized property. Recall that after the Norstar was seized in September 1998, the ship owner applied for its release in January 1999. The public prosecutor turned down the request because there were still investigative exigencies. Investigative needs outstanding. Yet, 5 weeks later, in February 1999, the public prosecutor accepted the conditional release of the vessel. To put it another way, Mr. President, whereas the ship owner took about 4 months to even request the lifting of the seizure, the public prosecutor was able to complete the investigation in only 5 further weeks. And he had no personal interest in the Norstar, as his owner was supposed to have. And certainly, Mr. President, that is not the mark of an unreasonable public prosecutor looking to abuse his power. I note in this connection that we heard nothing yesterday about the erroneous descriptions that Panama gave earlier this week, describing the temporary seizure as a confiscation that was sine die, because a confiscation, which is not a seizure, is sine die. As Panama now appears to accept, there was clearly nothing confiscatory or sine die about the seizure. And yesterday, Panama has vehemently asserted that Italy is hiding behind Spain and attempting to evade its responsibility behind Spain. It is important, Mr. President, that I draw your attention to the applicable legal regime under the 1959 European Convention on Mutual Assistance in Criminal Matters. Panama does not dispute that this is the applicable legal regime to the request for execution of the decree. Let me recall Article 3 of that convention, which is the key provision in the instant case. It provides, and I quote, "The requested party shall execute in the manner provided for by its law any letters rogatory relating to a criminal matter and addressed to it by the judicial authorities of the requesting party for the purposes of procuring evidence or transmitting articles to be produced in evidence, records, or documents." End of quotation. Thus, for the European Convention, the fundamental principle governing the execution of a letter rogatory is that of the locus regit actum. The meaning of the maxim is that the law of the place governs the execution of the request for mutual assistance, as opposed to the principle of the forum regit actum. The principle of the locus regit actum is not peculiar only to the European Convention that I just mentioned and which applies in the instant case, but rather is well established and widely utilized by states in cooperation in criminal matters worldwide. The International Court of Justice discussed this principle dealing with an agreement between Djibouti and France in the case of certain questions of mutual assistance in criminal matters of 4 June 2008. More specifically, the court stated, and I quote, "The obligation to execute international letters rogatory laid down in Article 3 of the 1986 Convention is to be realized in accordance with the procedural law of the requested state. Thus, the ultimate treatment of a request for mutual assistance in criminal matters clearly depends on the decision by the competent national authorities following the procedure established in the law of the requested state. While it must, of course, ensure that the procedure is put in motion, the state does not thereby guarantee the outcome in the sense of the transmission of the file requested in the letter rogatory," unquote. I may note, Mr. President, that Article 3 of the Convention in hand basically reflects Article 3 of the Strasbourg Convention of 1959. Mr. President, members of the Tribunal, coming back to the instant case, it clearly emerges that from Article 3 of the 1959 European Convention, that once Italy issued the decree of seizure and requested the Spanish authorities to execute the seizure, the Italian letters rogatory were executed by Spain according to its internal rules and procedure. In detail, from the arrest onward, all measures adopted towards the MV Norstar were governed by the Spanish legislation, such as all the modalities for the physical apprehension of the vessel, the appointment of the custodian, the inventory of all goods on board of the MV Norstar, including fuel, the decision on ordinary vessel maintenance. Thus, Mr. President, it is not by chance that the custodian, as we know for sure from the facts of the case, was the Spanish Port Authority in Palma de Mallorca. And equally, it is not by chance that, contrary to Panama's assertions, after the decision of the Tribunal of Savona in 2003, which released the vessel finally and definitely, Italy could not but rely on Spanish authorities for having executed the release and the return of the Norstar to Intermarine SPA. In conclusion, Mr. President, Panama's assertions that Italy manipulates Spain in order to evade its responsibility is simply and patently unfounded. To be sure, and Italy does not dispute that, as the tribunal found in its November 2016 judgment, it was up to Italy to later request Spain to lift the seizure. But that does not change the fact that Spain was responsible for the execution of the seizure and the custodianship of the vessel until the time that Italy requested the lifting of the seizure. Indeed, that is why Italy had to request Spain to lift the seizure. That can only be understood if Spain was in control of the ship until Italy requested Spain to lift that seizure. Mr. President, I should briefly respond here to the mischaracterization of President Esposito's evidence by opposing counsel yesterday. Yes, President Esposito said in response to a question from Judge Pollack that, and I quote, "The general rule is that whoever has issued the seizure order is in charge of the whole situation," unquote. And that, I quote again, "If Italy arrests a ship, whoever has issued the seizure order is responsible for taking care of the ship," unquote. But Mr. President, members of the tribunal, and I cannot emphasize this enough, President Esposito was clear that this was his opinion, and I quote, "if Italy arrests the ship," unquote, which was not the case. Indeed, Judge Pollack's question was, and I quote, "if Italy arrests a ship, who is responsible for taking care of the ship? The owner, the Italian authorities, or other authorities?" Opposing counsel disappointingly misled the tribunal by omitting the crucial context which changes everything. To be clear, Mr. President, President Esposito was opining on what would happen within Italy if Italian authorities arrested a ship on the request of the Italian public prosecutor. President Esposito was clearly not opining on which state bears responsibility for executing a request for seizure from another state and the modalities of custodianship thereafter under the Strasbourg Convention. Mr. President, members of the tribunal, Italy strongly opposes the argument made by Panama since its application, including yesterday, that the judgment of the Tribunal of Savona was not full and final. And it would have not been full and final, according to Panama, and I quote, Savona prosecutor appealed the decision in front of the Court of Appeal of Genoa despite having full knowledge of its illegal conduct when ordering and requesting the arrest of the Norstar, as well as of the aggravation of the damages that would accrue for its unlawful decision over the passage of time, unquote. Mr. President, this is simply not the case. And this is a matter of Italian law, which is a clear-cut matter of fact before this tribunal, for which Italy has abundantly proved evidence. But Panama keeps ignoring Italy's evidence, keeps ignoring Italian law, keeps complaining about Italy's pleading Italian law, while then Panama pleading wrongfully Italian law. But we are supposed to be pleading about international law. And the facts speak for themselves. The revocation of the decree became final, Mr. President, on 20 March 2003. The appeal lodged by the public prosecutor did not concern the MV Norstar. Indeed, the public prosecutor did not request the Court of Appeal of Genoa to suspend the order to return the vessel, Mr. President. The judgment by the Genoa Appellate Court of 2005 only concerned the acquittal of the accused, which was plainly upheld. In sum, Mr. President, once the Tribunal of Savona had decided on the unconditional release of the vessel, and once the decision has been transmitted to Spain, the Italian judicial authorities no longer had jurisdiction regarding the Norstar. It is for this reason, Mr. President, that on 31st October 2006, the Genoa Appellate Court answered to the Spanish authorities that it was not for it to decide on the demolition of the vessel. Mr. President, I see that I am approaching 4:30, and I need to stay on my feet for about 10 to 15 more minutes. I may continue, or I may allow you to decide to have a break.
Mr. Tanzi, indeed, your statement is approaching to the end. Therefore, I will allow you to continue your statement.
I thank you very much, Mr. President, and so I'll do. Opposing counsel yesterday referred to the Italian naval expert as follows, and I quote, "First, the expert, Mr. Matteini, has assumed false assumptions regarding the ship's condition. Second, the expert, Mr. Matteini, has assumed false legal and technical requirements with regard to the operational capability of the ship," unquote. I may note, Mr. President, the pictures presented by Panama in yesterday's hearing, they have been extracted, as indicated by opposing counsel, from private rather than official websites. And I may recall, Mr. President, that Captain Matteini had stated during his testimony that his information was acquired from official websites recognized by the IMO. The statement given by Captain Matteini is in line with the article of Diario de Mallorca produced by Panama. The article attests that the vessel had entered in port of Mallorca in March 1998 and was in state of abandonment in April of the same year. The photographs presented by Panama portray close-ups of the decks of the vessel and the engine room. However, there is no record of the source and the dates of these photographs. The captions of the photographs appear to have been added at a different time. Yesterday, Panama reported a part of Captain Marteini's testimony, omitting a crucial part of it. Opposing counsel quoted Captain Marteini as stating that, and I quote, "For sure, had the vessel looked like that, then my evaluation would have been different," unquote. Yet opposing counsel omitted the rest of the sentence. In that sentence, Captain Marteini clarified, but again, we would need to consider the necessary technical update that it had to comply with. End of quotation. Opposing counsel also referred to a series of photographs taken between 2010 and 2015, in which the status of the ship was defined as active, which opposing counsel considered, quote, "rather surprising unless you believe in the resurrection of the ships," unquote. However, there is nothing surprising in that statement, as the ship is defined as active because it is no longer under effect of the seizure. Panama claimed that Norstar did not need to conform to the new technical requisites imposed by the 73-78 Marpol Convention because its dead weight was below 500 metatons. However, the threshold set by Marpol is of 400 metatons and includes the Norstar. Moreover, it is necessary to keep in due regard, next to the weight, the category of the cargo, which is to be combined with the relevance of the determinants of the weight of the ship, especially if it is gas oil, due to its inflammatory nature and its related flash point. This is why the Norstar had to comply with double hull legal requirements set by the Marpol. And at the time of the events, we know for sure that at least opposing counsel and witnesses claim the use of the Norstar was to transport gas oil, not fresh water. If it had intended to change its business, it had to incur major renovation works and costly costs. Captain Marteini's declarations are valid also in respect of the valuation of the ship. For example, the expert could not have realistically considered a different use for the vessel, as this was not an available option at the time of the decree of the seizure. I just alluded, Mr. President. For the transport of bioproducts or fishing industry waste, the vessel would have to undergo a remodeling of its structure. It would have been unthinkable, Mr. President, members of the tribunal, to load the tankers with waste flowing through tubes designed for gas oil. Mr. President, I'm finally coming to a close. In my final remark, Mr. President, I will be addressing an issue which is not meant to be procedural, and it has a highly substantive importance in nature. In March 2016, Italy filed preliminary objections under Article 294, paragraph 3 of ITLOS, and under Article 97 of its Rules of Procedure. and it consciously did so to avoid starting preliminary proceedings under Article 294, paragraph 1 of ITLOS and Article 96 of its Rules of Procedure. Italy did so on the assumption that a state party to the Convention would not file an unfounded claim. That assumption was also based on the fact that Panama had almost 18 years to prepare the case before filing it. However, Mr. President, by the end of the merits phase, including what we heard this week, Panama has remarkably failed to substantiate its claims, while handling issues of evidence and documentation in the most appalling way. In particular, as illustrated on Wednesday by Professor Caracciolo, Mr. Busco, and myself, the evidence and arguments produced by Panama against the higher evidentiary and argumentary thresholds required at the merit stage with respect to the prima facie ones show that nothing in the conduct complained of by Panama, which is attributable to Italy, can possibly constitute a breach of Article 87 of the Convention and of Article 300. But much more than that, Mr. President. Now, in the light of the full record, those provisions appear not to be even relevant to the present case. Furthermore, Mr. President, my considerations regarding Panama's repeated failures concerning the burden of proof that I illustrated on Wednesday and my colleagues have corroborated in their speeches remain unaltered in the light of what we heard Panama say in its second round. Most importantly, I must emphasize the last-minute reliance shown yesterday by opposing counsel on self-serving pieces of evidence coming from self-interested witnesses in an attempt to paper over the obvious gaps in its documentary evidence. Such poor evidentiary background, Mr. President, members of the Tribunal, together with the lack of substantiation of its legal arguments, renders Panama's claim manifestly unfounded. Mr. President, distinguished members of the Tribunal, this concludes my presentation, and I may kindly ask you to call the agent for Italy, Mr. Aiello, to present Italy's submissions. And I thank you very much for your attention.